morning, everyone. Welcome back to the 1 Hour series. Tonight, we have a stream with an entertainment lawyer, and you'll learn a lot of things you need to know as an actor, performer, dancer. We'll cover a bunch of things that you might have not even known. Marc is an entertainment lawyer, as I mentioned, but I'll let him talk a little bit more about the projects he's done so you know the kinds of questions to ask him. We'll jump right in because this is our first lawyer on the stream, and I'm sure we'll have a lot of questions for him. So let's welcome Marc. Here he is.
Hello, everyone.
Hi, Marc.
Thank you very much for having me.
Thank you for doing this. I think as actors and as performers, a lot of us wonder, can I post this video of like a music from another artist on my Facebook? And if I post, is it copyright infringement? What do I do? Questions like that, I think we all want answered. So, but before we begin, could you tell us a little bit more about, I don't want to say tell us about yourself, please. This is not a job interview, but just the projects you've done and look what kinds of stuff you do, etc.
Yes, so I'm an entertainment lawyer, as you mentioned. I work at a large law firm called Shepherd Mullen. I'm in the New York office. You can see the Empire State Building behind me. I previously worked at a boutique law firm in New York called Cowan Debates, Abrahams and Shepherd, and also another law firm called Skadden Arps. But when I was at Cowan Debates, I did a lot of theatrical work. We represented one of the talent agencies named the Gersh Agency and handled all of their deals for their creative talents. So playwrights, book writers, composers, lyricists, choreographers, set designers, and pretty much everyone other than the actors and actresses in the Broadway space. And then also I did work for, handle deals for actors and actresses separately from that, and also represented some producers and investors of Broadway shows. So I've been able to sort of work in the industry as a lawyer from all the different angles and see how all the puzzle pieces connect to make the Broadway shows. And now my practice actually focuses primarily on film and television works for primarily cable and paid television channels like Showtime and Viacom CBS. And I also do a lot of podcast work as well, representing Spotify. So broad range.
Thank you for that. Yeah, you've pretty much done everything in entertainment. Now, as you were talking in my head, I'm like, oh, I should ask him this. I should ask him this. And actually, before I forget, because this wasn't on the list of questions, you mentioned working for film and television. So we actually had a discussion with my friend the other day about doing fan films. So say Lord of the Rings fan film. If you do something like that, is that considered copyright infringement, or is that are fan films okay, pretty much?
So I will say it depends. There is a defense to copyright infringement, the fair use doctrine, and it is a test that looks at various different factors. But generally, it's not advisable to create what's called in copyright law derivative works and trying to like adapt or change a film. And I remember there was a show called, there was a show, but then also a film called The Son of Rambo, where like it was about like kids trying to like recreate the like action film Rambo. And like, I don't think anyone wants to be on the other side of a lawsuit from a major film studio. So I would not advise creating any sort of fan films.
What about something like, okay, here's Lord of the Rings idea, and we take, say, not even the characters from the film itself, but we say, oh, okay, well, there's like elves and there's rangers, so let's create a film that's separate from Lord of the Rings, but has the same idea. Is that allowed, or?
So I should preface all the information that I'm giving is for informational purposes. Although I'm a lawyer, I'm not anyone's lawyer who's watching this. So I do think it is good to consult a lawyer, and everything that I'm saying is not legal advice. It's just for informational purposes. But generally, within copyright law, you cannot copyright an idea. It's just like many books and films are about murders. No one can be like, well, the young girl gets murdered in a shower and I copyright that. Like girls can get murdered in showers in multiple films, and that's just how it works. So if you wanted to create a film or story or other creative work that featured elves, that's something that you could do. If you wanted to take something that's really a something that's protected in copyright law, something very specific that is in the Lord of the Rings world or universe, like taking I'm not too familiar with it, but like Frodo, and like taking him from the Lord of the Rings universe and putting him in London or something and creating this other alternative reality story, you would not be able to do that because well, you may be able to, but it gets a little more complicated. But I think generally when it comes to creating these sort of derivative works, even though you may have a valid fair use defense and be able to do it legally under copyright law, it doesn't stop the film studios from going after you for copyright infringement. And those legal fees can add up a lot. So I think generally it's always best to create something original and not try to use characters from pre-existing property or any other elements.
All right. Well, to follow up on create something original, this question I kind of asked or kind of prefaced it at the beginning of the stream. When you post something, let's say your original choreography to someone else's song, and you're like, here's me dancing this song, or here's me doing this cover of this song from this musical, or dancing to, like I said earlier, Beyonce's song. And then I personally have seen a lot of people on Facebook or Instagram say something like, this is for entertainment purposes only or educational purposes only. I do not own the rights to the song. And they think that ensures that they won't be sued. Could you speak on that a little bit?
Yeah, so that does not protect you from a lawsuit. There's no like magic words that you can utter and suddenly you're free from any sort of liability for copyright infringement. And then there's also a misconception among a lot of creative people that like, oh, it's okay if you only use 5 seconds of a song or something. There's no like 5-second rule or anything. And I think every website has a different way of handling stuff. I know that YouTube has a certain policy regarding copyrighted works and a mechanism for like enforcing those rights. But I think that if you are going to post yourself dancing to someone else's copyrighted music, that would not really be permissible. There's a whole system in place for licensing music, and it's pretty complicated. There's like multiple parts. There's basically the right to the recording of the songs and then the right to the underlying musical composition. And you would need to get both of those, if both the rights from the artist who wrote the song and then sometimes the studio that actually owns the recording of the song. So it is a little complicated, but to answer your question, you do need the rights to that stuff. Most people online, probably 90% of the people on YouTube do not have the rights. It's up to the rights holders whether or not to go after people. A lot of them don't, but you don't want to be the person who is the one who gets a lawsuit in the mail.
Now, what about when you post videos on YouTube and it says, this song is copyrighted. However, the copyright owner said you could use it if they monetize your video, if they put ads on your video. Does that mean you're safe, or they can still be like, yeah, we put ads on your video, but still pay us money because you used our stuff?
So do those people actually have an agreement with their rights holder?
Well, no, it's YouTube that says, for example, I do a lot of covers of songs. Mm-hmm. And while sometimes YouTube doesn't recognize a song because it's my voice and not the original singer's voice, sometimes the karaoke track that you use, YouTube recognizes that. And they're like, okay, well, 15 seconds of your song are copyrighted by this place. And this place actually allows you to use to post stuff on YouTube as long as they can monetize it, or it'll be monetized if you post it.
Yeah, so that's sort of like what I was discussing before with how certain websites have different ways of like policing everything. YouTube does, I think, have a policy where it gives the rights holders an option over whether or not to remove the video or to basically monetize it. So that may be sufficient, and I'm not too familiar with the specifics of that or even music license. I've done some music licenses, but I'm not a music lawyer. And I think, although that may be fine, there's multiple parts to music licensing, and like I would need to sort of like examine everything and make sure. But you may be able to have like the master recording, but not necessarily like the underlying rights to that.
Yeah, because I know Facebook, if you post, I think they do, like if it's a 30-second clip or less of someone else's song, it's fine. But then if it's a longer, so if you play Beyonce's song and you post the dance and there's not enough background noise to like disguise the song, then Facebook is like, okay, we're gonna remove the audio because the copyright holder said you can't use it. So they just remove the audio.
Yeah, I mean, it is really fascinating what's happening, especially with TikTok recently, because TikTok, I'd say, is probably one of the greatest music discovery tools in the past decade, maybe of all time. But you've seen a lot of songs which have been generated a lot of popularity on the service, and as a result, just shot to the top of the Billboard charts. So it is really interesting. But the people, to my knowledge, a lot of the users on TikTok who are using these songs don't have the rights to them. And so it's really sometimes up to the record labels over whether or not they want to pursue anything, because it does benefit them sometimes to have that sort of exposure and to go viral on the services.
Yeah, those are exactly my thoughts. Because on one hand, you want people to pay, but on the other hand, social media is so powerful that you're like, okay, I mean, maybe Beyonce doesn't need, a lot of advertising, but some maybe smaller artists are like, yeah, I want my musical to be seen and heard by many people. So if someone does a cover, I want it to be out there, and great if I can monetize it. So,
yeah, it's really a business decision for the rights holders over whether or not to seek legal action over stuff like that. But I think, I mean, within the past year, within the theater world, the cast album for Beetlejuice blew up, and I think that really helped the show overall, because just within a certain community, I'm not sure whether or not that community had the money to go see the shows, but you had a ton of like 10, 12-year-old kids singing the music from that show. So it is a really powerful way to get the message across and break through as a young artist.
Yeah, exactly, because not everybody can afford Broadway tickets, but if it's out there online, even 30 seconds of it, people are like, oh, what's this? They look it up, and there you go. It's a famous musical, so it does work. Now, I'm not sure if social media is a part, like also an area of your expertise or not. No, not. But I'm just curious because on Instagram and TikTok, when you make, like, let's say an Instagram reel, you can add music, or even you make like an Instagram story post, and they give you an option for choosing like all these different songs you can add to your post. Now, how does Instagram do that? Do they just kind of pay people for using their songs, or do they have some kind of an agreement?
So, I mean, I would need to look at the terms of service of the of using Instagram. But I would imagine if they were going to let you use certain songs that they provided to you, they probably do have all the licensing and stuff in place to allow you to do that. They may be fully cleared and stuff, but I'm not familiar with the specifics of their policy.
No, I totally assumed that. But yeah, I was just curious because there's all these songs, and I'm like, I wonder how they do it. I know for Spotify, you pay for Spotify, so I guess the artist, like, however many times the song is listened to, maybe the artist gets like a cut or something like that. But for Instagram, I was like, I don't know how they do it.
Yeah, I mean, generally though, if you're going to use external music that you like upload or anything, to the extent that's possible, that's sort of where you sort of dangerous territory,
Yeah.
I'd say. Because I think a lot of people, I feel like most of the stuff that I see on YouTube, I sort of question, like, do the people have the rights to this? And the answer is probably no.
Mm-hmm.
But sort of what we were discussing before, it's up to the rights holders as to whether or not they want to like bring an action. And you will see videos being removed all the time. But sometimes it does help certain like TV shows or musical artists sort of break through. So.
All right. Well, thank you for that. Now to, I guess, continue on the copyright journey a little more. I was going to ask you about, well, I guess you said music law is not really your thing, but, and you did mention something about this earlier. I'm not sure if I got it right though. If, or actually for some shows even, I know I was in a show a couple of years ago, and they said you cannot share like a minute or more worth of stuff from the show, but you can share if it's, I think it's, if it's between like 30 seconds and a minute, you can share it, but only if it's not just like a whole segment of a song, as long as if it's like 10 second segments put together into 1 minute or something, that's allowed. So is there like special rights you need to get for that when you do a show?
So are you talking about like a theatrical, like live stage show that are?
Yeah. So let's say let's say some theater gets rights for a show, and then they want to promote the show. So for promotion, can they post just the whole song, or does it depend on what kind of rights they have, or do they
exactly? So it sounds like what you're talking about is like stock and amateur licensing, and those theaters, the producers will make a deal with the licensing companies that have the rights to those shows, usually like MTI or Concord, which recently bought like Samuel French. And in those agreements, it'll specify certain restrictions. I feel like it's sometimes like 7 minutes or so in the area. Like you can only use like a certain segment, a certain number of minutes from the show for promotional purposes. And there's also restrictions on recording the show. Although it's interesting is because of the pandemic, I feel like a lot of that has changed, and now you can do live streams of shows and it's not as restrictive as much. But there are always limitations, usually in the agreements directly with the rights holders over how long of a segment you can share from the show.
All right. Well, that answers that question. Now, well, I guess most of the stuff is going to be about copyright, because actors are who just do so much stuff that it's like, oh, I want to perform that song. So we had someone ask a question about being a cosplayer. So if you're a cosplayer and you make all these costumes or buy costumes and you take photos in them, how legal is that? If it's like Disney or, you know, or like anything known?
It's interesting. Generally, I feel like it could be copyright or maybe even trademark infringement, because those rights holders, like if I designed a dress that was like a fashion designer or something, like Chanel and Burberry, they try to protect their brands and their creations. And I feel like a lot of the studios, if it's an iconic character like Nintendo with Mario, they want to prevent people from having like that hat and this overalls and everything. So I think that it could be a dangerous thing to do legally. There is that fair use doctrine, and a lot of the analysis hinges upon how transformative it is. Are you adding new elements and sort of changing the meaning of or commenting on it, providing some sort of criticism? It is a somewhat tricky analysis, but I feel like generally with cosplaying, a lot of the studios are in favor of it because it sort of generates sometimes merchandising revenues for them or other thing. It sort of creates a whole community. And I think a lot of the rights holders from video game studios and developers to film studios and developers ultimately do not want to alienate their fan base. And so I think they sometimes make a decision over whether or not to pursue any sort of legal action. But legally, there could be an issue there. Like it could be a violation, but they may decide not to do anything about it.
Yeah, so that's it's I feel like with just like with music, they're like, okay, we want people to dress up as Spider-Man or something because we want Spider-Man to stay relevant all the time.
Yeah.
So we can get more sales for the people who are fans.
Yeah, and I feel like yeah, I mean, there's a lot of things that you see all the time online that just are not legal. I feel like just most people don't have the rights to do a lot of stuff.
Yeah.
And I would imagine that Disney, through Marvel, like has the rights to Spider-Man and that whole iconic uniform that the character wears. So, I mean, if they wanted, they could probably go after the guy in Times Square, maybe, who is creating a similar thing. I think if DC Comics, their competitor, created a superhero who looked exactly like Spider-Man, but maybe instead of like, I think Spider-Man's red and blue, maybe it was like red and yellow or something like that. That would be a really interesting lawsuit that they may be able to go after. So, yeah.
Nice. I just want to do a quick shout out to Lawrence, who's watching. Lawrence is a dancer, and he actually appeared on a couple of our streams here. So hi, Lawrence. Well, and hello, everybody else who's watching. Say hi if you're watching, because I can't see you, obviously, unless you comment. Now, back to copyright then. So actually, before I ask that question, let me ask you this. Copyright law is international, correct? So it's not like, oh, I can use this from like a show that's made in, I don't know, France and do it in the US for free and not get sued.
So actually, copyright is nation by nation. The US has its own copyright laws. France has its own copyright laws. There's at least one convention I know of called the Berne Convention, Berne, and there's various countries that like are signatories to it. And there's basically a relationship where if it depends on the country and like there's a lot of specifics, but it would allow you to pursue a claim internationally in the foreign countries. It gives you certain protections there against sort of copyright infringement. But it is nation by nation. So you sort of need to do that analysis, and it sometimes gets a little complicated when you're dealing with works that, when there's like this whole thing, the public domain, which is like works that you can use and you don't need the rights for, they're no longer protected under copyright. But some works go into the public domain in countries before they do in like the US. And there was an example recently, the show on Broadway, The Inheritance, was I think loosely based on Howard's End, the book. I think that's the name of it. And it went into the public domain in the UK, but was still protected in the US. And it created this whole sort of legal mess for the producers to deal with. But that's just another instance in which how the nation by nation patchwork approach to copyright can cause complications.
Wow. So if someone were to take a show from France, written by someone in France, and just do it in the US without buying copyright, what's likely to happen?
So if you infringed a French show in the US, I would need to check the relationship between France and the US, but the French rights holder may be able to pursue a lawsuit against you in the US.
Okay.
For copyright infringement.
So technically, if the two countries don't have an agreement, then technically if you steal someone's work from that country and do it in another country, then nothing's going to happen because the countries don't have.
I think they probably could do something. It depends. I mean, there's just it's a very fact-specific situation, but I think it just may be a little more difficult for them to pursue that sort of claim.
I think something just became clear to me. So all the like illegal copyright infringe stuff that sometimes you can like download books online or download movies online,
Yep.
and they have to move the server to another country, and then it's like legal in that country. So this is why, right? Because the two countries don't.
I'm not sure if that's really the reason. I think it's just, it's more difficult to go after someone in like Estonia because
Yeah.
like if someone's there, you may need to extradite them to the US court system and like actually get them here. And then it's just like mechanically, it causes a lot of complications to enforce that because
Oh, okay.
you'll need to identify like who they are, get their information, and I'd say international law is like this whole other like area of the law that some people specialize in. But that's like international copyright enforcement is like this whole area unto itself that I'm sure like Nike and other like multinational companies deal with all the time. But it's like, it's pretty complicated. And there's a lot of reasons the people who host those websites may want to be elsewhere. It's probably just trying to be difficult to catch.
All right. That's
Yeah.
interesting to know. All right. So another thing, because I know a lot of people do this, using someone else's work. I'm just going to give specific examples here. So let's say someone has a house party for Christmas and they're like, oh, we're going to hire like 5 singers to sing through Les Mis for us. And Les Mis is obviously copyrighted. And they're like, well, it's not, nobody's paying for tickets. It's just in my basement. Nothing's going to happen. So is anything going to happen, or can anything happen if people say, oh, it's not professional or it's not for profit?
So if they're going to do it in there, technically it would be copyright infringement of Claude Michel Schoenberg and like Alain Boublil. But realistically, if you're doing it in your house, like I don't think they're gonna like learn about it and do anything. But it is copyright infringement, and that's sort of like what we were discussing earlier. Like it's up to the rights holder whether or not to enforce anything, because like if you violate copyright, like you violate it, like it's not like you immediately like get like a letter in the mail. Like the rights holder needs to learn about it and then decide like, is it worth hiring a lawyer, like going after them, finding a legal thing. A lot of companies will they'll send you like a cease and desist letter and be like, look, we've learned about it, don't do this again. And nothing ever happens. Like you just agree that like, okay, I did it, I'm done. Like sometimes they'll be like, pay us what you earned from that. There's a lot of ways that companies can respond. But yeah, I mean, something like that, I think would probably be copyright infringement.
Yeah, I remember I talked to a lawyer from Canada about the exact same thing, and he said what you said. Like, well, they're probably not going to do anything, but if they decide to make an example out of you and just go after you so nobody else does it.
I mean, there are stories about that, like the kid who like downloaded some like songs from Napster and then got like sued for like $60,000.
Wow.
I mean, there are stories like that, but ultimately, I think like I would imagine like for something like that, like it helps them to an extent by like increasing the exposure of the show and everything, and they don't want to alienate the people who love their work. I think if you were going to do that sort of concert at Radio City Music Hall and have it televised, then they would make an issue of it. Like I feel like once you sort of increase the stakes and there's more money potentially at issue, then like you're sort of going deeper and deeper into the deep end of copyright law. And I think that's where you can cause some problems. The more high profile it is, the more money that would be generated from it. But yeah, I mean, it's a lot of analysis, both on the legal side, whether or not it is infringement, and then also more of a business analysis then on behalf of the rights holder, whether or not to do anything about it.
Yeah. Now, what about, once again, a music question, I guess, but what about people who, say, perform at restaurants and bars and do covers of other people's songs? I heard that restaurants apparently have some type of like a copyright thing they have to pay for, and then you can sing whatever songs. But I don't know,
Yeah.
could you, if you have more info on that?
So with that, there is a blanket license at certain venues through these performing rights organizations. There's like BMI and ASCAP, and so with those licenses, they would be able to perform those songs, but you would need to make sure whether or not those venues have those licenses. And that was a whole thing during the campaign recently, where some songwriters objected to politicians using their music at the as like a warm-up video. Like I remember, I think actually it may have been when
Yes,
like
yes.
One More
I know what
Day,
you're
maybe.
talking about. Yeah.
Or
He was like, I think it was during like a Trump rally or something.
I think so. And I
And the
remember,
singer was
and
like, I don't want you using this song.
yeah. And there was an interesting thing with, it may have been Betty Buckley with Memory from Cats,
Mhm.
where she objected to Trump's use of it, which is interesting because she wasn't even the rights holder. It's Andrew Lloyd Webber. Um, but yeah, it was a really interesting thing. But they, through these venues, they did have that license. And I think they, as a result of everything, they may have looked into some sort of like restrictions that they were going to build into those licenses, allowing the rights holders to like maybe say like they can do it at any venues like bars or certain concert halls, but not and like sports arenas, but not at like political rallies. But I'm not sure whatever came of that. But it is a really interesting issue. And generally, if the venue like a sports arena or something does play that, it's permissible.
Oh, Dan is saying Red Hot Chili Peppers. I guess that was it.
Yeah, I think they
Their
did too.
song.
Yeah.
Yeah, yeah, yeah. Okay. I totally forgot what I was going to ask. Oh, yes. Okay. So about singing songs at restaurants, do artists have anything to worry about when they go to a restaurant to perform or to a bar? Or is the bar responsible for the copyright infringement if the artist sings something they're not supposed to?
So I think as an artist, you would want to make sure that they do have that blanket license in place. And if you do have like a whole set, it may be worth consulting with a lawyer and making sure that all the rights you need are in place. I think generally with those sort of agreements with a restaurant or other venue, I would want to like any aspect of that agreement, it may be good to run past a lawyer just to make sure that you're not liable for any sort of other stuff that could happen. I feel like as a lawyer, our job is to sort of think of the worst case scenario possible and think of all the bad things that could happen and protect the clients against that from occurring or limiting their legal liability in that event. And I think that there could be a lot of stuff that happens in the restaurant that I would want to make sure that you're protected against. If someone, if a patron of the restaurant trips on your equipment and then sues you, or if someone falls off their chair as a result of a loud noise and like sues you, and you're not controlling like the sound system or something, I would want to make sure that the artist is protected. There's a lot of random stuff that could happen. And I think that in the sort of agreement, I would probably I always think it's always good to run any sort of thing that you're signing, any paperwork that binds you. And I would probably run that past a lawyer to make sure it's good to go.
Yeah, just in case. Better safe
Yeah,
than
I
sorry.
mean, I think you need to prevent against a worst case scenario from happening. And although it's low stakes, I think some agreements from restaurants, they may think that the artist performing there is not represented by counsel, and it could just be very slanted in one way. And you just need to make sure that whatever you're signing doesn't put you on the hook for something that's unreasonable. And yeah, I think that's a key thing to be looking for. And make sure that, I think when you're reviewing a contract, if you're not represented by counsel, I think just really read everything. I always say to read everything before you sign it, make sure that you understand everything. If you have any questions, to ask the other side, but really make sure that it's something that you're comfortable with. Because like, I feel like a lot of times, like with software, especially when they like have a license agreement in front of you and you just like click through, like it could say like you give up like your house and your firstborn, and like most people don't read it. So it's just like, it's important to like read and make sure you understand everything.
Yeah. Before you said the click without reading, I was about to say, oh, so you mean we shouldn't just scroll through and click accept?
Yeah,
just
it's always
initial
good
down
to
here.
read. Yeah, I think it's because I'm a lawyer. Whenever anyone asks me to sign something, and it's even things like going like whitewater rafting, those like liability waivers that you need to sign. Like you don't really have a choice in the matter, but it's good to like read it and know what you're getting yourself into.
Yeah. So you must get to whitewater rafting like 3 hours beforehand. It's like, let me just check the whole thing.
Yeah.
Oh man, yeah, but you're right though. You're right. You should really read things that you sign, because who knows what's in that contract. Then they read it back to you. They're like, yeah, actually you signed this, and here's your signature. So now you got to do it, or else it's a lawsuit.
So.
All right. Let me just read some comments here. Oh, Lawrence is saying producing a show in NYC without rights would get you an immediate cease and desist. It would shut down the show. Plus, a theater wouldn't book you without proof of rights. I did not know about that. Is this only New York, or is it like across?
No, I think it's true everywhere. I think it's always important. The first thing I always tell people, make sure you have the rights. And I think generally, if you're going to create a show that is based on something, it's always good to speak with a lawyer early, because I dealt with a high profile property recently, a show that was based on someone's life. And they didn't negotiate the rights for that person's life story until after it was already all over the place in the news and released and everything. And at that point, like you can sort of get into a hostage situation where they could be like, I want $1 million. And you're like, well, I don't have that. And then they're like, okay, then I'm going to sue you. So you just, I think it's always good to engage a lawyer early, just because you want to catch something before it's too late. And regarding the rights, always good to get the rights in place for any sort of show that you're producing in the event that the rights are necessary. And yeah, the theaters may require it. Insurance companies, to the extent you have them, they're going to want to see that. If I was a smart theatrical investor, I would want to make sure that that whatever property I'm investing in has the rights. I think the rights are the most important thing. I mean, even though I would say I'm an entertainment lawyer, all day I deal with rights. You need to make sure that if I'm representing the production company, the producer of a television show, that we have the rights in place that are necessary to produce that show. If I'm the artist, I'm also going to have to make sure the rights are in place. Like the rights are really the most important thing, I'd say.
Wow, yeah, I didn't know you couldn't even book a theater until you had the rights. That's interesting.
I mean, you may be able to book the theater, but the thing is, if there's a copyright infringement claim, they may sue the rights holder may sue the theater as well. And depending on your agreement with the theater that you're leasing, you could be on the hook for those legal fees.
Yeah.
So I think it's very important. And I remember very early on in my career, I was invited to a client's show. And in the play, they started playing this music from the Beatles. And I was thinking to myself, like, we don't have the rights to this. And that was never they never told me about that. But I think like you need to be careful, because in the event that like someone in the audience happens to like be at I don't even know which label controls the Beatles rights, but you don't want to get sued, and they'll sue the theater. I mean, they'll sue like everyone in the room. I feel like sometimes when I negotiate deals for podcasts, like the artist's like, oh, like what's the real concern about getting sued? And like if a mic falls and hits someone and injures them, like the person who's injured will sue every single person in the room, like the engineers and everything. They'll sue the company that's producing it. Like everyone could get sued. So it's always important to get the rights.
So you mean the audience members too could get
No,
sued for just going to
I
the
don't
show?
think they wouldn't get sued, but I think like
But like if they
ultimately,
wanted to, technically they could.
no, I mean, I think anyone could sue anyone.
Well,
The
yeah.
lawsuit would be dismissed, but I find that in a lot of these cases initially, like rights holders will sometimes sue everyone involved, and then that person, whatever entity is sued, will need to hire a lawyer and get the case dismissed against them. But that's going to incur substantial amount of legal fees. So I think sometimes the strategy is sort of like a shotgun approach and just to sue as many people as possible and see what sticks. But yeah, I mean, that's not advisable, but that's sometimes what happens. So yeah.
Yeah, we've all heard stories about people just suing for the sake of suing. It's like, oh, maybe I'll get some money out of it.
Yeah.
Who knows? All right, one more question. So since we do have some dancers watching, for example, there is a movie or like a stream of the live stream of a show recording, and you're a dancer, and you decide, okay, I'm gonna take this choreography from the movie and dance it for fun, and just post it on social media. What is that pretty much the same as taking somebody else's music then?
I mean, it depends on the Yeah, it's the same thing. Depends on the relationship between the choreographer and the movie as to who owns those rights, but it would be infringing upon their work. So yeah, that is a potential claim there.
All right.
So yeah, I mean, that's also one of the things, sort of as before, whether or not they decide to do anything about it. Because it does, if you give credit to the choreographer and everything, it's not going to help the legal analysis, but the choreographer may feel less inclined to sue you when you're giving them like credit and like helping raise their profile. But I see it all the time on YouTube, like people copying dances and stuff from other people and like reenacting famous iconic dances, Gene Kelly and other people. So it's yeah, it's an issue. You're infringing on the rights, but it's unclear whether or not anything would be done about that.
All right. Well, all this talk about copyright. If you do get sued, if you're unlucky, let's say you put on a show and didn't have rights, and they found out and they decide to go after you, or you're a cosplayer and decide to go after you. And if you have money to pay, I'm assuming that they can make you pay. If you don't have money to pay, what happens? You declare bankruptcy and then just nothing happens, or can they go after you the second you get money?
So I think before you get sued, you would most likely get a cease and desist letter first. And then usually, I think generally the approach is to send a cease and desist letter, stop what's happening. And then it's sort of like a first strike. And if that doesn't work, then you'll get sued. And in the event you don't have money, you're in trouble because they can get a judgment against you, and then you may need to declare personal bankruptcy, or like it'll cause a lot of issues. So yeah, I think there's sometimes statutory damages, and if you don't have the money, then you're in trouble.
All right, but if let's say you don't have money, you can't pay, you declare personal bankruptcy, and then let's say suddenly you get rich, you win lottery in a couple of years after that, can they come after you, or once you're bankrupt, that's it, it's over?
So I'm not a bankruptcy lawyer. I think that they would still be able to pursue you and garnish wages and stuff, but I'm not familiar with that. I don't do litigation anymore, so I don't go that far in the process. But yeah, I haven't dealt with that sort of situation where someone had to declare bankruptcy. But I would imagine that you can't just like declare bankruptcy and be like, okay, I'm free now. Like, I feel like you may still be on the hook.
Yeah, because that's like an easy way out. Because people could be like, oh, I'll just make sure I don't own anything or don't have any money in my account. And then just be like, yep, I'm bankrupt. And then just keep doing shows for free kind of thing. And just be bankrupt every time. So I'm sure there's something. So your advice would be just if you get a cease and desist letter, just kind of stop and don't push your luck there, right?
I mean, sometimes I think it's sort of worth looking into it if you are making a movie and you've invested significant amount of money and stuff,
Mm-hmm.
and you are really confident in it. I would speak with a lawyer and see like what your legal basis is here. I think sometimes rights holders will send cease and desist letters when they don't have a legal basis for shutting down a production, but they just don't like it. And sometimes, like, for example, certain estates may decide like, oh, like, even though like it is a transformative work and it's protected under fair use, I just don't like what that person is doing with the person's work. Like, let's say you have To Kill a Mockingbird or something. I think that's still protected under copyright. And let's say Harper Lee, someone decides like, oh, I'm gonna like take like Atticus Finch or something and put him in another film or another like story, an alternative universe. So sort of like the Lord of the Rings thing. Legally, you might be able to do something like that. It's a little complicated and it requires a lawyer to really go through the analysis. And even then, there's no real certainty because it's up to a judge to decide. But the rights holder may be like, yeah, I just don't like that. I don't think it's good quality. I don't want Atticus associated with that. I'm just going to send this cease and desist letter and shut it down. And so depending on the situation, if I wrote that and I was confident that it's fair use and I have a deal with Simon & Schuster to publish that book, then I would have Simon & Schuster bring the cease and desist letter to them and have them sort of go through it with me and decide what to do. But yeah, generally, if it's just like you uploading something and it's like a song or something and you don't have any there's no real reason to continue, I would just sort of pull it down and be like, oh, sorry.
Whoops, didn't know. I mean, you could still get sued if they wanted to, but
yeah, but I would follow the cease and desist letter.
Yeah. Because I think a lot of us heard about that story of a Florida couple getting sued by Disney because they had their own mascot business or something, and I think it was like Winnie the Pooh or something that they had the mascot of, and it was like a terrible quality one.
Yeah.
And they lived right by Orlando, right by Disney. So they were like, we don't want people thinking this is Disney. And they asked them to stop and they didn't. So they got sued for I think it was $1 million or something.
Yeah. I mean, I won't comment on Disney because they're a client of mine, but I think that a lot of these big companies are aggressive with they need to protect their brand and everything. Yeah. So if they're concerned that there's an inferior product on the market that infringes their work and is not up to their standards, and they're not getting any money from it, they will go after them to shut that down. And what was interesting actually recently was on TikTok, where you had people creating musicals of shows to rights that they didn't own the rights in, like Ratatouille, and then also Bridgerton. Disney could have shut that down most likely. And then Netflix could have shut the rights, the Bridgerton adaptation as well. So it is just really interesting to see what happens with that stuff.
Wow. I wonder, I feel like Disney, everybody, because Disney is so powerful, it's like you don't want to mess with them pretty much. Because it's, if they've been able to change the copyright law so their mouse doesn't go public domain, then what other things can they do? They're like, yeah, we've been changing laws so our business can benefit. So if you're just a little guy using Winnie the Pooh and it's an ugly Winnie the Pooh and they say to stop, you better stop, right?
Yeah. I mean, as an individual, I would not want to be on the receiving end of a lawsuit from a big studio or a network or anything. And if I got a cease and desist letter for allegedly infringing upon the copyright of entity, I would probably just comply with it. It's not worth the legal battle. I mean, I think engaging a lawyer to defend yourself in an action, even writing an answer, would be like probably $25,000 or sometimes 50. Like it's just a ton of money. So I think artists who get a cease and desist letter, it's probably best to review it maybe with a lawyer if you're confident, but probably complying with it. So.
Well, that was a great conversation. It's like we're all thinking about Disney and all these big companies. Now, we are almost out of time, everybody. So if you have any other questions, make sure to ask them now. I will ask this question from Robert. He asked this a while ago. How much of this should an agent already know block the talent from? So I guess, and if I don't know if you work with agents and like talent managers, yep. Do they already know the copyright stuff and all the legal stuff, or should you still consult with a lawyer?
I would hope that they know. A lot of them probably don't because a lot of them are not lawyers. I think depending on the size of the agency, some of them do have business and legal affairs departments. So I think you can sometimes run contracts through them and have their lawyers look at it. But I would hope that they are flagging these types of rights issues and copyright stuff. I think I would hope a lot of them have some sort of understanding and can advise their clients properly. But to the extent that they're not able to, I think it's good to engage a lawyer to run through this stuff.
All right. Always good to consult someone who specializes in the area, not just a lawyer. It's got to be an entertainment lawyer, right? Because obviously,
I think generally, depending on the issue, but I think specifically for theater, if you have a theater issue, then it's always good to speak with a theater lawyer because every industry is different. Film and TV are related, but theater is a world unto itself. Music is a world unto itself. Podcasts are a whole separate thing. And even like advertising and other areas, like lawyers specialize, a lot of entertainment lawyers specialize in certain areas. Mm-hmm. So it's good to speak with specifically a lawyer who is familiar with the industry standards and practices in the area that the issue is relating to.
Makes sense. All right, another question quite a few people asked, or a variation of the question, so I put it together as one question. You spoke about the contracts before on the stream, but maybe if you could give more details to people who, let's say you get a new role, not necessarily as an actor. What if you get a role as a producer, or like you get hired as a producer or as a director, and you have to sign a contract? Other than reading the contract, what else should they do? Any tips for that?
I think, well, other than going through with a lawyer, I think a lot of people have the misconception, this is sort of general advice, but I think a lot of people have the misconception that when they get a contract, it's not subject to negotiation. And as a lawyer, like I negotiate contracts all day long. That's sort of what I do. I think a lot of people, like when you are installing Microsoft Office, the license agreement comes up, you can't negotiate with Microsoft on any of that. Like you need to sign it to use the software. But when you are an actor or actress or being hired for something, usually there is an ability to negotiate. It depends who's on the other side. But I think it's like if there's any like provisions that you don't agree with or you want more clarity on or want to add certain things, like it's definitely worth raising it. And I think a lot of people don't recognize that they have the ability to negotiate that stuff. And then also as an actor or actress, to the extent that the person is a member of Actors Equity Association, I would say it's good to read the contracts that exist between equity and whichever producer. Sometimes it's the Lower Theater, sometimes it's the Broadway League, but I think it's good to be familiar with what your rights are to make sure that while while actually doing what the agreement is for, that you are being accorded all the rights that you're entitled to have. So I think that's good. But I mean, within every agreement is different. And I think that there's certain issues that arise in some agreements, but not in others. But I would be concerned about what you're giving, what you're getting, and any other sort of exposure that you could have, I'd say.
All right. Well, thank you for that. I think we've taken a lot away from tonight's stream. Now I have like a million more questions, but those are more specific. So talk to a lawyer. All right. So we are almost out of time. So I just wanted to ask you, well, we have people watching from not just from the US. There's people from Australia, there's people from Canada. So obviously, if you're in Canada, hire a Canadian lawyer because it's the law is different in different countries, right?
Mm-hmm.
But if there are people in the US and the artists watching the stream are saying, oh, I need a lawyer and I don't know how to get one, and they want to contact you, can they do that? I guess, well, through your law firm, right? Or do you not represent actors? Is it only?
I do. I do some talent work. I do more studio, but I represent all sides, and I have a profile on the law firm's website, and my email address is there, and so is my phone number, so people can call me. But I think in terms of finding a lawyer, I think it's good just to search online. If you're looking for a theater lawyer, type theater lawyer. There's some organizations, chambers and partners, and others that rank the top people in the industry. But I think it's good to sometimes interview multiple lawyers. And I sort of think this is true with any sort of vendor. It's good to speak with multiple people. A lot of lawyers will give free consultations, I think, where you can sort of tell them what sort of legal needs you have. And I think it's important to get the, usually the two elements of any sort of agreement. There's sort of multiple ways legal bills can be structured. Sometimes it's on a commission basis where you give up a certain percentage of your revenue from something, which is common for talent agreements. Other times you pay by the hour. So it's important to find out what the hourly rate is for the lawyer that will be working on your case. And then also some of them require a retainer, which is like a down payment towards the legal fees. So I think it's important to really meet with a lawyer. And I think ultimately, when you speak with a lawyer, what you're looking for is someone who can be your partner in the negotiations. You want someone, I would say, who thinks like you, but is also a good advocate for you. And I think you really want an advisor, someone who you can turn to, someone who's accessible, because I recently served as the co-op of my board, on the board of my co-op building in New York. And we had to hire a lawyer, and it was interesting because I'm a lawyer and I'm in the service industry and I'm always serving clients, but it was interesting to be the client for once. I'm working with a lawyer and seeing like, oh, like I didn't like that because I would contact my lawyer and he wouldn't be accessible. So I think you want to find a lawyer who's really accessible, someone who you think is competent and able, someone who you can turn to, and someone who's just like nice and that you gel with, because I think there could be a really great lawyer available, but not the good lawyer for you. It's sort of like choosing a doctor, I would say, the same sort of research. And I mean, both of them are licensed professionals who are in the service industry, and you want someone who you feel comfortable working with. And I also think within the industry, sometimes it's good if you're a young up and coming performer. It's sometimes good to get someone who has experience, but is also as innovative and progressive sometimes as the clients, because I feel like within the legal field, there's a spectrum of how progressive certain lawyers are. And some people are more creative in coming up with strategies, and some are more traditional and have been like, well, it's been done this way for 60 years and that's the only way I'm going to do it. So there's a lot of different considerations.
All right, thank you. And everybody who's watching, if you would like to contact Marc, his contact information or the website to his law firm will be at the end of the stream after we go offline. You'll see an end screen with all the contact information. Now, Marc, any last words? Anything else? Any other words of advice? I know you've given a lot of advice to performers today, but anything else you think actors or performers should know other than what we've discussed today?
No, I feel like we've covered a lot of ground. I think most importantly, know what your rights are to the extent you're entitled to any through any agreements, and make sure that you have the rights to stuff. Because, and I think another third tip is to engage a lawyer when it's necessary and do it sooner rather than later.
Yeah, just to avoid any mistakes.
Yeah. So, I mean, you just want to make sure that like you're not doing anything that could haunt you later on, because sometimes they have situations. Oh, and another thing I should mention is that there are some great organizations I think it's usually state by state, but in New York, there's an organization called Volunteer Lawyers for the Arts, which provides free legal advice to pro bono clients. So people who don't have the resources to hire a lawyer, there's certain eligibility requirements, but they try to help artists who cannot hire high-priced lawyers. There's certain resources in California and in Illinois and elsewhere. And in the event that you are not in a position to financially afford a lawyer, there may be organizations that can help you. And at least with Volunteer Lawyers for the Arts, the person who runs it she knows her stuff. So I think that, and they match people up with sometimes people like me and sometimes lawyers at other great firms. So I think that that may be another resource that's available to people that they may not be aware of.
Oh, yes, thank you for that. I personally wasn't aware of it. And I'm sure a lot of people watching weren't either. All right, well, we are out of time. So thank you so much, Marc, for doing this. This is very different from what we usually do because we usually feature actors or directors or agents or casting directors. So, but I think this is very important to know, this side of the business too. Because as an actor, it's not like you can just trust your fate to whoever's doing the show. You need to also know some details yourself as well.
Yeah, absolutely. Thank you for having me.
And thanks everybody for watching. We have other streams coming up, so make sure to follow this page, or I also posted a link to the Facebook group where all these streams are either announced or when we go live, they appear there as well, so feel free to follow there. But the next stream coming up is, we have one for film and television again. We'll be talking about the different episodic seasons and stuff like that. And we have another stream with a casting director, Tara Rubin Casting. That will happen all the way in August. So stay tuned for that. We're just finalizing the date still. Stay tuned because we have more things coming. Thank you again, everybody. And thank you so much, Marc, again, for doing this. We appreciate it a lot. All right, everyone, have a great night and a great weekend. Bye.